Colleagues, ladies and gentlemen, it's really a privilege to be here on this special occasion, 70 years of entering into force, the European Convention. It's a very important date, very important figure, and it's really a pleasure, and I would like to thank the Central European Academy and also Ferenc Mádl Institute for inviting me and giving me the opportunity to speak in front of you. So, the topic of my presentation is freedom of assembly and association, which, of course, is one of the fundamental rights in the democratic societies. Maybe it is not a right that has been so frequently before the court, which is okay, which is then the good situation. The states obey this right and respect, but there are some cases, and I hope I will, in the next 20 minutes, be able to present some of them. We all know that the Article 11 just gives everyone the right to freedom of peaceful assembly and freedom of association, of course, two of the rights, including the right to form, to join trade unions and so on, and especially the paragraph 2 of the Article 10, like the Article of 11, and like in the Article 10, Article 9, it gives the possibility to restrain and to restrict those rights. Also, this is the case regarding the freedom of assembly and association, and these rights can be limited if it is prescribed by law and necessary democratic society, and if those limitations pursue a legitimate aim. All of this will be addressed later. Of course, although it has its autonomous role in the sphere of application, the Article 11 really has to be considered together with other articles, 9 and especially Article 10, when the aim of the exercise of freedom of assembly is the expression of personal opinions, as well as the need to secure a forum for public debate and the open expression of protest. And the link between these two articles is particularly relevant where the authorities have interfered with the right to freedom of peaceful assembly in reaction to the views held or statements made by participants in a demonstration or members of an association. So this has been confirmed in numerous cases before the European Court of Human Rights. In the view of its importance, of course, the right to freedom of assembly should not be regarded restrictively, and to avert this risk of restrictive interpretation, the court refrained from formulating the notion of an assembly or exhaustively listing the criteria which would define it. So basically the concept of assembly is an autonomous one, and it covers, of course, gatherings which are not subject to domestic legal regulation, irrespective of whether they require notification or authorization, or whether they are exempt from such procedures. And likewise, some of the gatherings, like the flash mob, could not be considered as assembly, irrespective of whether it fell under the notions of public event. Assembly is defined in particular by a common purpose of its participants and is to be distinguished, of course, from a random agglomeration of individuals, each pursuing their own cause. Although the primary purpose of Article 11 is to protect the right of political peaceful demonstration, like we can say that the Article 10 is primarily here to protect some kind of political expression, it cannot be, both articles cannot be narrowed only to political demonstration or expression, and also the Article 11 is applicable to the assemblies of essentially social character concerning the cultural gatherings and religious and spiritual meetings, which was addressed a little bit by my colleague Dalibor. Also, the Article 11 of the Convention, of course, only protects the rights to peaceful assembly, a notion which does not cover a demonstration where the organizers and participants have violent intentions. But of course, how we can predict some violent results of a demonstration. The guarantees of Article 11 therefore apply to all gatherings except those where the organizers and participants have such intentions, incite violence, or otherwise reject the foundations of a democratic society. Depending on the underlying facts and the nature of the complaints, the question whether an assembly is peaceful may be examined as a question of applicability or when determining the existence of interference. Of course, the burden of proving violent intentions is always lies with the authorities to prove that those demonstrations will be violent. If there is a real risk, even if there is a real risk that an assembly might result in disorder as a result of developments outside the control of those organizing it, it does not as such fall outside the scope of Article 11, paragraph 1. For example, even obstructing traffic roads, arteries, and so on, as a part of demonstration could be considered peaceful. And although not an uncommon occurrence in the context of the existence of freedom of assembly in modern societies, physical contact purposely obstructing traffic and the ordinary course of life in order to seriously disrupt the activities carried out by others is not at core of that freedom. And also, occupation of public buildings is generally regarded as peaceful conduct despite its unlawfulness and the disruption it may cause in a society. In a number of cases, even when the demonstrators had engaged in the acts of violence, the court held that the demonstration in question had been within the scope of Article 11, but the interference in that right mentioned in the beginning by paragraph 2 of Article 11, the interference with the right was justified to prevent disorder or crime. So also I can say that the right of freedom of peaceful assembly comprises negative and positive obligations on the part of the contracting states, and the states first must not only refrain from applying unreasonable indirect restrictions on the right to assembly peacefully, but also safeguard that right. Although the essential object of Article 11 is to protect individuals against arbitrary interference by public authorities, there may in addition be positive, of course, obligation to ensure peaceful conduct. Of course, the authorities cannot guarantee this absolutely, and they have a wide discretion in the choice of the means to be used. And also in this area, the obligation under Article 11 of the Convention is an obligation as to measures to be taken and not the results to be achieved. In particular, the court has stressed the importance of taking preventive security measures, such as, for example, ensuring the presence of first aid services at the site of demonstrations in order to guarantee the smooth conduct of any event, meeting, or other gathering. The duty to communicate with the leaders of a protest demonstration is an essential part of the authorities' positive obligations to ensure the peaceful conduct of an assembly, to prevent disorder, and to secure the safety of all involved. Of course, we have here the part of the situation, of course, when there are counter demonstrations, and the authorities must duly address all the situation and all the statements regarding the demonstrations and counter demonstrations. But I don't have so much time. So basically, I will now move on to the restrictions on the right to freedom of assembly. And of course, it is not an absolute right. We have very small number of absolute rights, of course, in the Convention and generally in human rights law. But an interference with the exercise of that right does not need to amount to an outright ban, legal or de facto, but can consist in various other measures taken by the authorities. The term restriction in Article 11, paragraph 2 must be interpreted as including both measures taken before or during a gathering, and of course those measures such as punitive measures which are taken afterwards. For instance, a prior ban of a demonstration can of course have a chilling effect on the persons who intend to participate in a rally and thus amount to an interference, even if the rally subsequently proceeds without hindrance on the part of the authorities. In cases where time and place of the assembly are crucial to the participants, in order to change the time or the place may constitute an interference with their freedom of assembly, as does a prohibition of speeches, slogans, and banners. Of course, a refusal to allow an individual to travel for the purpose of attending a meeting amounts to an interference as well, and the applicant's unjustified deprivation of liberty on their way to demonstration, preventing them taking part in the events. Of course, then we have the violation of more than one human right. Of course, there are two types of restrictions. The first type comprises conditions on the exercise of the right to freedom of assembly, in particular rules of the planning and conduct of an assembly imposed through mandatory notifications and authorization procedures. And the second type of restrictions comprises enforcement measures such as crowd control, dispersal of an assembly, arrest of participants, and subsequent penalties. I would now like to move on to 3 conditions which are needed to be fulfilled in order that the interference in the freedom of assembly would be legal and lawful. First of all, prescribed by law. This expression, described by law, not only requires that the impugned measure should have a legal basis in domestic law, but also refers to the quality of the law in question, which should be accessible to the person concerned and foreseeable as to its effects. In particular, the norm cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen and others to foresee to a degree that is reasonable in the circumstances of the case the consequences which a given action may entail. Of course, the experience not only with this article but with the others shows that it is almost impossible to attain absolute precision in the framing of laws. Now we have this situation. I hope I will have the time to address this issue of COVID-19 and some limitations which were introduced by the states, and also the absolute, and to invoke some of the situations, some laws that are not so precise. And and also the court does not requires the absolute precision in formulating this law regarding the Article 11 as for the other articles. Let me move to the legitimate aim, of course, the second requirement, and this requirement of a narrow interpretation of the exceptions to the right of freedom of assembly, of course, just implies the list of legitimate aims enumerated in paragraph 2 of Article 11. The prevention of disorder, which is one of the most commonly cited permissible grounds for the restriction placed on the exercise of the right to freedom of assembly, and of course it must be interpreted narrowly. Also, the second most common reason is protection of the rights and freedoms of others, and it's very often cited as a legitimate aim. And of course, they're very closely linked, because of protecting the public order is, of course, protecting the rights and freedoms of others. So basically, we had some examples regarding also in Russia, but also in other countries, the restrictions of the assembly and demonstrations or of the LGBT population. And it has been a problem, especially also in Serbia, but in other countries. And many of the countries have invoked the protection of morals as one of the reasons in order to prohibit or to ban these kind of demonstrations. This was not accepted by the court. Of course, the other reasons, protection of public order, could be involved. The third condition, and this proportionality issue and the condition whether it is necessary in democratic society, is very much important when examining whether restrictions should be considered. The court, to give a final ruling on the restrictions compatibility with the convention, should have to assess all the circumstances of a particular case. So the measure in question must answer a pressing social need and be proportionate to the legitimate aim, and the reasons adduced to the national minorities to justify it must be relevant and sufficient. And the national authorities must apply standards which are in conformity with the principles embodied in Article 11 and base their decision on an acceptable assessment of the relevant facts. The proportionality principle demands that a balance be struck between the requirements of the purposes listed in paragraph 2 and those of the free expression of opinions by word, gesture, or even silence by person assembled on the streets or in other public places. Also, the breaches of other provisions of the Convention, such as Articles 3, 5, and 6, in relation to participation of an applicant in a peaceful assembly, have been also very important and determinative to the court findings as whether something is necessary in democratic society. If those things occurred, or inhuman degrading treatment, torture, or other violations of European Convention, then it's very easy very easy for the court to prove, to decide that there was a necessity in a democratic society. Maybe the time, okay. Okay, public events related to political life, which I mentioned in the beginning, that basically the political assemblies may be the most important. They, of course, must enjoy a stronger protection under Article 11. And, well, just there are the rare situations where a gathering may be legitimately banned in relation to the substance of the message which its participants wish to convey. And so the government should not have the power to ban a demonstration because they consider that the demonstrator's message is wrong and it's not in line with the authorities. So even in the course of jurisprudence, there were even some cases that are, you know, if I can say tricky, or I can say that they should maybe resolve the other way. Or, for example, even when a group of persons requests a cession of a part of the country's territory, and in that way demanding fundamental changes and constitutional territorial changes, that the court said that it cannot automatically justify a prohibition of assemblies. So in the case United Macedonian Organization Ilinden versus Bulgaria. So that doesn't automatically prohibits the assembly of citizens. Of course, the other cases, for example, a criminal penalty that was for having a poster with the photograph of Abdullah Öcalan, the Kurdish leader, during a march along an authorized route was not found justifiable, as it could be regarded as a form of expression calling for the use of violence, armed resistance, or an uprising or propaganda for a terrorist organization. So basically I wanted to, that is regarding these three conditions about the, I think that my time will soon expire, but I would like also to address the issue of COVID, and also we are all aware what kind of measures in each of particular countries have been imposed, and it clearly interfered with the right of peaceful assembly and association. Now we should all look through the frame of the paragraph 2 whether those limitations have been justified and necessary in democratic society, and if they pursue the legitimate aim. If we say it's a legitimate aim, protect of the rights and freedoms of others, yes, especially the elderly people, that to prevent the gathering and spreading the virus, okay. But in a minute, yeah. Okay, but if this is the legitimate aim, and now the question of the other two conditions prescribed by law, I have found that although we will wait for these judgments, we all know, and yesterday there was mentioned that the judgments, that we all know that the judgments of the European Court of Human Rights are not so easily to get, right? And that we should all, that the people are waiting maybe too much, but okay. But we will see what the outcome of those cases will be, which were some of them referred to the Grand Chamber and so on. But for example, in Croatia, there was a prohibition on gathering on public places. It was put a large number of people, this sentence or this syntagma, the large number of people, and what it was not defined in the law or in the order. What does it mean, a large number of people? So we cannot say that this condition prescribed by law has been fulfilled. Sorry for Alexander for this, but we will see if the cases are how the cases against our countries will be decided. And of course there are some other cases where we will see how the court will evaluate, will judge the COVID situation and the restrictions of the freedom of assembly and other freedoms. So thank you very much. I apologize maybe for rushing a little bit.